5th, 2019 at 7 p.m. Meeting in council chambers. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Thank you very much. Let's have the roll call, please.
Chair Kevin Seyfried,
Present.
Vice Chair Charles Ernst,
Present.
Commissioner Kenny Each,
Present.
Commissioner Jason James,
Here.
Commissioner Bob Pashon,
Excused.
and Commissioner Michael McDermott.
Present.
We have quorum.
All right. Do we have approval of the minutes for January 3rd?
So moved.
Mr.
Each. Second.
So Commissioner Each moves for approval. Do we have a second?
Second.
Mike McDermott, all in favor?
Aye.
All right, minutes are approved. We'll go ahead and sign this. Thank you very much. All right, for communications, review and approval of the 2019 Planning Commission timeline. I do have a question on that. Your schedule that came out with that showed who was appointed by who, if you are familiar with that? No, you're not.
No, that's the secretary.
Okay. Well, you know, I think that unless we change the ordinance, I was looking at the reference to myself, and I was appointed by the mayor.
So what do we have in there?
You see, that was the odd thing. My position, for whatever reason, has been coterminous with the mayor.
So you will be up in May.
Theoretically.
They all expired in May of this year.
Then you get reappointed by the new mayor.
Maybe. Maybe not. We're back where we were 4 years ago.
Yeah, I'm listed as an alternate.
Right, and
And-
Mr.
and-
Ernst is sitting here as a, you know, the vice chair. That's not exactly an alternate.
So
No,
Marlene,
that's what it says on the website too.
Are you,
I'm here now, I see it.
yeah, she's taking a look at it right now.
And I'm not sure when my term is up
I think most of us are up in May of 19 this year.
this year.
Right, except for Mr. Pichon.
Yeah.
Okay.
Well, we'll have a commission of one.
Well,
And
it's a
then
long time
annually,
between
we're
now and
supposed
then.
to.
Yeah,
elect
of
the
course.
chair.
Is this an election year?
Only the chair is
Yes.
elected.
Well, it is. A little late with the campaign signs. I haven't seen any yet.
Yes, to say the least.
So one of the things that you need to take care of as far as part of housekeeping is, annually, you were supposed to elect a chair and a vice chair. And so, Mr. Chair, we need to elect a new chair and vice chair. We didn't do it at the last meeting.
I make a motion that we elect our current chairman as the chair and our current vice chairman as the vice chair.
I'll second that.
All right. All in favor?
Aye.
So moved. That's handled. And you'll fix that that memo that went out for us because there's some things. Charlie Ernst.
Charlie Ernst.
Right.
Yes, it doesn't.
Yeah, we're going to, Marlene has a little bit of updating she needs to
Yeah.
tackle on the website.
That needs to be fixed. Okay, if we've got that worked out, we have no public hearings. And what is this new board member orientation refresher? There's really nobody new here.
Well, it's actually, it's mislabeled. It's actually your annual refresher.
Okay.
So every year, should have been at your first meeting, but we wanted to put together a slightly different orientation for you and refresher for you. So we have that prepared. It will be, if you're ready, I can be more than happy to
Yeah,
start.
let's do it now and
Alright.
move through this so we
Alrighty.
don't have any unnecessary delays tonight.
Well, again, this is your refresher session for your annual. For the record, I'm Debbie Love. I'm the city planner. Section 2-202 of the LDRs talk about the composition. It's 7 regular members and 2 alternates. 5 members are needed for quorum. Your staff is, actually, I'm your liaison, and the secretary is Marlene Weir from the Community Planning Department. As you know, right now we meet the first Tuesday of every month at 7 o'clock. Your advisory to the City Council. This goes back to what we just talked about. There are 4 members' terms in the second Tuesday in June of the odd year. 3 members, the term ends the second Tuesday in June of an even year. The officers are the chair, the vice chair, and the secretary. And you must be a resident. You can't have any elected or work office or work for the city, and you can't have any liens or fines or code enforcement violations in order to serve. We are encouraging applicants to apply as well. Some of your powers and duties then are established in section 2-201, and you take a look and you make recommendations on amendments to the text of the LDRs, zoning map amendments. You also do review and make recommendations on the text of the city's comprehensive plan. The first 2, the amendment to the text of the LDRs and a text amendment to the comp plan, you're going to be doing tonight. Land use plan, land use map amendments. You also approve the city's evaluation and appraisal report and approve any evaluation and appraisal report based comprehensive plan amendments. And as a reminder, you need 4 affirmative votes for any zoning or land use amendment, so keep that in mind for tonight. Additional duties that you do is you review proposed plan developments. So when you get in a plan development, which you will be, such as Solomia in other areas of the PD, you'll be reviewing those plan developments. Of course, you do the allocation of the density bonuses through the conditional use permits. You review those. You look at development agreements. You just did one of those at our last meeting. You also do review and make recommendations on any traffic modifications or street closures that come before it goes to City Council. You also make a review, make recommendations to City Council on right-of-way, alley abandonments, as well as any right-of-way abandonments or vacation. You make comments and review plats and waiver plats. And campus development master plans. You're going to be seeing the Johnson & Wales campus master plan maybe at your March, at most your April meeting. Moving on, some other things that you do is you take a look at the ranking of the 5-year capital improvement plan. That's part of the comprehensive plan, which is why you all look at that, because it becomes an amendment to the comprehensive plan.
What do you mean by ranking?
Of the projects that go into the comprehensive plan. I mean, I'm sorry, into the capital improvement program. You'll actually make comments on the ranking of various capital projects that are proposed.
As far as priority?
Priority,
In the funding
uh-huh.
or
Right.
or timelines or?
Priority. So when we have, for example, a capital improvement program in the comprehensive plan, are those capital projects that move your comprehensive plan forward? It's not sidewalks, unless you have comprehensive plan amendments that said you're going to provide 100 feet of sidewalk annually in your comprehensive plan. So that would be a policy that your capital projects would implement. So you'd all then provide your recommendations on ranking of those type of projects. That's actually done, it's supposed to be done annually, and I don't believe we've been doing that annually. You all hold workshops on the CDBG action plan, which you all have already heard that from Marie in housing. Again, working with housing, you look at and make recommendations on the SHIP program, as you all remember. Some others that you do is the CDBGs and recommendations for the CBOs. So as you can see, you have a wide variety of duties that you cover. as well as any type of special projects or studies. Then you provide another forum for public hearings. Some resources that we're going to make sure that you get updated on, and Marlene's going to give you an application that she'd like for each of you to fill out for your membership, because when you're a member of APA, you'll have access to the Commissioner, which is a periodical that comes part of your planning magazine. And then the Florida Planning, you'll get the monthly newsletter from the Florida APA. And then, of course, the actual APA website. Once you become a member again, as you all may remember, there's all kinds of great information that's available there for members, including what they have now opened up, Planning Advisory Service, which used to be a separate membership. Now you can go on there and look up anything that you want to learn anything about, and under the Planning Advisory Service, you get all of this great research. I use it a lot. So with that, I'm going to turn it over to
Debbie?
Gary Held. He's going to, yes, sir.
On this application for
Okay.
Connect, we're just gonna fill out the top part, correct?
Correct.
The choose and connection and compute your costs, that's not us.
No, we'll take care of all of that.
We're really just dealing with one little box in the top
Right.
left-hand corner.
Correct. And Marlene will make sure she collects them from you tonight, because we really want to get you signed back up. You already budgeted for those. And we'll make sure you have the adequate resources that you deserve.
Thank you, by the way.
Yes, thank you very much.
That
You didn't
was-
forget, we heard you.
We never understood why that just disappeared a couple of years ago.
It has to be renewed annually, so it
okay.
just was probably missed during the renewal process. So we apologize for that. We'll make sure that that doesn't happen to you again. And with that, I'm going to go back to the PowerPoint, please. And Mr. Held is going to go over his refresher course in avoiding legal pitfalls.
But it's so much more fun when we fall into them.
No.
Think of all that legal education that you would
Getting out of it.
otherwise never get a chance to use.
Well, that might give Jennifer more work since I'm not litigating these days. So good evening, everyone.
Good evening.
Good evening, sir.
So I'm following the same outline that we did last year. I don't know how much you remember from last year's presentation, but we thought it'd be worthwhile to go over it again, since this is an important obligation that you have to satisfy these various legal requirements as you go about doing all of the work that Ms. Love has set out for you. So under the Sunshine Law, as you all know, meetings of appointed board members at which official acts are to be taken or discussed must be at public meetings. The city must provide reasonable notice, and minutes are required to be taken. So if a meeting or discussion by planning commission members was held but not conducted according to these requirements, then any decision or action made by the commission is void. It also subjects you to liability, both non-criminal and criminal liability for acting contrary to the Sunshine Law. So I'll go through that. So why is this important to you? Because first, compliance honors the transparency that the Florida legislature intended when it required public bodies to provide notice of the meetings, take minutes, and have board members not discuss matters on which official action will be taken outside the board meetings. Second, the statute provides that unknowing violations, meaning you didn't intend for it to happen, but it happens anyway, are non-criminal infractions which are accompanied by a $500 civil fine. Knowing violations are considered second-degree misdemeanors. One thing I didn't do last year is go through some cases to see whether there actually is prosecution, how the courts are treating violations of the Sunshine Law. So there's this case, October 21 of 2014, out of Orlando, where a private citizen was holding discussions with the various board members of an expressway authority, and it was not in compliance with the Sunshine Law, meaning he was conveying information about how other people might vote on a matter to other board members. And the state attorney wanted to prosecute this citizen. Well, what the court says is the First Amendment protects the lobbying activity of the citizen, and even though he may have overstepped, it was really the responsibility of the board members to make sure that there was no Sunshine Law violation. And the court actually said if the violation of the Sunshine Law occurred, the appropriate target for prosecution was members of the authority and not private citizen. So if you, let's say are induced by a citizen to have a conversation which you think steps too far, where he or she has discussed with other board members how they might vote on a particular matter, you should stop that conversation, because that would be a violation of the Sunshine Law on matters that are foreseeably coming before you. So even if an application has not been filed, but you know that it is the kind of thing that would be filed, and that person has discussed with other board members how they intend to vote or might vote on it, you should stop that conversation and not be part of it. So different settings in which, possible pitfalls might occur are social functions. Go to a cocktail party where 2 of you are in attendance, and it may involve a third party or not. You should avoid talking about any matter that could be coming before the board. I often, when I see 2 commissioners at my other city together talking, I say something like, I hope it's weather, food, or sports. And, just remember that you're not supposed to be having that kind of a conversation. If you go to, there are some settings where you are certainly entitled to be together and having, where there are conversations going on or discussions of things that might come before you. It might be a lecture, might be a seminar, might be a candidate's night. What you should avoid getting involved in is a kind of cross-conversation where other board members are in the audience and you're having a conversation with, let's say, a proctor or a moderator or somebody who's putting on the meeting, and questions are going back and forth with you and other board members. That should not happen. And you should probably exit from that kind of situation, because that would be a violation. So one of the exemptions from Sunshine Law requirements is when you're performing a fact-finding role in a group. That is something that would be organized by the city attorney's office and staff. So and they will follow the appropriate requirements. But if you, for example, are going to a site in a quasi-judicial matter, there's an application pending that's site-specific, and another board member shows up at the same time, you should probably not go through that site visit with that other board member. It's only a moderate inconvenience. Either ask him to leave or you leave. But what you're put into a situation of is defending what you didn't say, even if you're both, honoring that you're not having a discussion. But if you both are asking questions of the owner of the site or the applicant and not having a cross conversation, that may be a problem as well, because you're doing it in front of the other person, and that may be considered a violation. When you are acting in your ultimate decision-making authority, that exception does not apply. It only applies when you're acting in an advisory capacity. So just be careful with that. Are there any questions about Sunshine Law? Okay. So we've talked before about public records law. Generally, so it's the public has a right to inspect or copy public records. Now, public records can include emails, computer records, planning commission minutes. For your purposes, the most important part would be either notes that you take or communications, written communications that you have with other persons. So if you're taking personal notes, which are temporary and not to formulate knowledge for purposes of the board, those notes are personal and not public record. And you can dispose of them, you don't have to maintain them, and you don't have to turn them over. But if you're using those notes like to preserve some information for a subsequent meeting, or to pass a note to somebody else. Those are public records. Not only is there a public records issue if you're passing notes, but that's a sunshine law issue as well. So you should not be passing notes together. And I forgot to comment, one of the often overlooked issues on sunshine law is when there's private conversations on the dais. You should try and avoid that. I haven't noticed that here, but sometimes when you have a new board member, they're not familiar, maybe they haven't received the orientation, they'd reach over and have a conversation with you about, an application. You should be careful and let that new board member know that that's not appropriate, that it's something to look out for. Sometimes you're, just casual, having a conversation. It's something that is a concern under the sunshine law. So, the only important issue on public records law for you was the notes, and they're private as long as you maintain them that way. Okay. We previously discussed quasi-judicial versus legislative decisions. There's additional procedures that you follow when it's quasi-judicial. Public is sworn. There's heightened due process requirements. So as part of those due process requirements, and you're sitting as quasi-judges, you're required to disclose ex parte contacts. But one of the interesting things to note about the quasi-judicial setting, I think, is cross-examination during a public hearing. The way the law is now, the only people who are entitled to cross-examine, according to case law, are the applicant or staff. And you have codified that pretty much in the LDRs, that only city staff, the applicant, and board members can cross-examine people who appear before you. But any member of the public who wants to speak cannot cross-examine another witness who is making a presentation to the board.
But the board can ask questions? Or
Yes.
We can cross-examine?
Yes.
Okay.
And that's provided for in the ordinance. So, again, ex parte communications, just a reminder, if anybody talks to you, and this is not a sunshine law issue, these are non-board members talking to you about applications that are site-specific, that are coming before the board, you have an obligation to disclose those communications prior to the vote. And the requirements include the identity of the person, the group or entity with whom, person, group, or entity with whom the communication took place, and it must be made a part of the record before final action is taken. There's also an additional issue when you receive written communications, like an email on a quasi-judicial matter. You are supposed to make that part of the record, and what you should do is forward it to staff so that they can put it in the file for public inspection. So that's an ex parte communication requirement that is accompanied, it's sort of related to both public records and sunshine law, but it's something you're obligated to do. And on the ex parte communication, so the disclosure that is supposed to take place, we make a point in the agenda of disclosures and communications. That's the time when you should provide that. And we've had some of this before, so you should be familiar with it. Any questions about either public records or
Well,
ex parte?
I know in the past, what always bothered me is a lot of times, and we've even gotten emails from the city telling us that there will be a presentation by a developer or something, and we encourage you to attend, which I never go to.
Right.
But I don't know where that, is there a line that should be drawn to your going
Yeah.
to any kind of a presentation by a developer or something that's, might affect a change in the
Is
comp
this like
plan
a
or
workshop
something?
or?
Well,
I haven't done that.
sometimes they're not public workshops. I mean, we've gotten emails from, like, Johnson Wales may send you an email that we're doing you know, invite you to an event that clearly is something that they want to make a presentation about their future or something like that.
So-
I'm just using that for an example,
So,
which could be no more than them trying to solicit
right.
your.
So the
your-
first question you need to ask yourself is this something that foreseeably could come before the board?
Right,
And so Johnson and Wales Campus Master Plan is something that would. And then your concern is whether it's a sunshine law issue you're going and whether it's a violation for you to appear.
yeah,
And sometimes, you know, if the city is co-sponsoring, which I don't know that they do, but I've seen that before, they can arrange for staff to take minutes and notice. But if not, you just need to be careful that you're not having discussions with other board members who might also appear. You know, as long as the conversation doesn't evolve into cross communications among board members, you should probably be okay. As long as you're listening to a presentation and not communicating.
of course, that
That's
goes for homeowners associations also,
Right.
correct? Which,
It's something to be sensitive to. So we previously talked about, well, conflicts of interest generally. You have an obligation to file a financial interest statement every year. I hope the city clerk's office is coordinating that with you. And that's something you should be diligent about. We had a board member in Miami Beach who failed to do it, and he was given a substantial amount of fines for doing that. So that's something you should pay attention to. On the subject of gifts, as a general rule, you do not accept any gift in exchange for your vote, any performance as a board member. Aside from those kinds of gifts, which are absolutely prohibited, you cannot solicit or demand a gift. But if you do take a gift, there are disclosure requirements that are required by both county law and state law. I don't remember any city law requirements
Gifts.
applying to board members.
Just employees.
Okay. So, you cannot accept a gift in excess of $100 from a lobbyist. And if the value of the gift is between 25 and 100, you need to file a form disclosing that gift. And, you know, I was going to tell the story of the planning director at Miami Beach was getting married, and he received a lot of gifts as, you know, wedding gifts. He actually had to file financial disclosure forms for those wedding gifts. Unless it's a direct family member or somebody who's clearly a friend not associated with the city, you know, you should be really aware. And, you know, when in doubt, contact the clerk's office or city attorney's office and clarify it. And the last item on the agenda, are there any gift questions? No. Last item that I included, because I think it's important to talk about, is the Kuntz case, which is unconstitutional conditions. It's important to remember when you are considering quasi-judicial items, site-specific items, that the conditions have to relate to the application, and the terms that the courts use are that it has a nexus to the project, and that the condition is roughly proportional to the effect or impacts that the project causes. You can't require something that's totally unrelated just because the city has a need for it. It has to be tied to the impacts or effects that the project is creating. So with that, unless there are any questions?
Because I actually had a slide here at the end for any questions, so. since
May
you
I
don't
may I
have
ask a question on, say with regards to that project that we had on, just off of West Dixie and 130th, and we made several suggestions about parking and possibly putting a pool on the roof and a rooftop gardens instead of the surrounding grounds. we made the suggestions, that was up to the developer to do it. Now, that would be permissible, is it not?
Right, those aren't conditions, and you never said that if you didn't do them, they would be denied. It's more like an accommodation.
So in other words, if we said, if you don't do that, we're gonna deny it, then that would be unconstitutional.
Well, then you'd have to evaluate to see whether it would be or not.
Okay.
I mean, you have to examine the relationship of that requirement to the project.
I got you.
For example, if there was a city pool nearby and you're talking about an apartment building that would overwhelm the city pool, maybe that's a reasonable condition. But that's something that, you know, should be analyzed with staff providing you a factual background and basis for the condition.
A really good example is we are a transportation concurrency exemption area. So technically, we can't require development to mitigate traffic impacts. State statute says that if we weren't a TCA, for example, you can only require them to mitigate their own impacts. So if the roadway is already failing, for example, you can't make them bring it up to non-failing because it's already failing. They can only mitigate, as Gary said, their proportionate fair share of whatever that mitigation is. So I always tell everybody, be careful about exactions. And that's the term that's actually used, is exactions, because in this case, what they were requiring was way over and above, and there was no rational nexus to their impact of their particular development on the stormwater? I think is a water management district. So that's all we ask you, is to be very careful in that. And I'll caution you as we go along that that's a dangerous piece of territory to go into. So just be careful with that. So with that, we'll, if you're ready to move into.
All right, we're ready to continue.
Yes, sir.
All right, we're now ready for the public hearings. We'll begin with PC 2-19, an ordinance of the mayor and city council of the city of North Miami, Florida, amending Volume 1, Goals, Objectives, and Policies of the City of North Miami 2016 Comprehensive Plan. More specifically, the future land use element thereof, in accordance with the requirements of Section 163.3184, 3, Florida Statutes 2018, and Chapter 29, Article 3, Division 11, Section 3-1102, A, and Sections 3-1105 through 3-1110 of the City of North Miami Code of Ordinances by amending the future land use element at Policy 1.18.3 to provide for residential use within the Northwest 7th Avenue Planned Corridor Development Overlay, PCD, as is permitted within other planned corridor development overlays, and to require a conditional use permit to allocate density bonus units in the PCD, providing for an initial hearing and subsequent transmittal of the proposed amendment to the reviewing agencies and/or any interested local government or governmental agency for review under the expedited state review process, providing for an adoption hearing and subsequent transmittal of the proposed amendment as may be amended to respond to comments from the reviewing agencies, to the state land planning agency for a determination of completeness, providing for repeal, conflict, severability, correction of Scrivener's errors, and an effective date. Staff report, please.
Certainly, sir. Again, for the record, Debbie Love, City Planner, Community Planning and Development. As the staff report indicates, and the PowerPoint, as the staff report indicates, this is, the purpose of this is to, and that long title, is to allow residential uses in the PCD on Northwest 7th Avenue. This amendment is actually sponsored by Councilman DeSalme. All the other PCDs in the city allow residential development. The when this was first established in 2015 in the future land use, which is what we're looking at now during the comprehensive plan amendments. My apologies, that better? Okay. Again, this is a comprehensive plan text amendment sponsored by Councilman DeSalme. This is to amend policy 1.18.3 of the future land use element and establish residential density in this PCD on this particular corridor. Other PCDs within the city allow residential at various densities. This is the only one where in 2015, when the PCD was established, they did not allow residential density. So after looking at doing the Chinatown master plan and talking with the community and the development community, Councilman Selme is sponsoring this amendment to establish that residential density of up to 125 dwelling units per acre. Additionally, this would also modify the fact that they're done by a conditional use permit. If you'll note that in the current future land use element, some are by development agreement, some are by conditional use permit. Whereas policy 1.18.2, I believe it is, requires us to use a conditional use permit as the method by which density bonuses are allocated. So we needed to change that to make sure that each of the PCDs reflect that you get the bonus of floating units, there's actually the right terminology, through the conditional use permit so that it's consistent. And again, it's also to require that within the Chinatown corridor, that area between 119th and 135th, that there are design guidelines that all the development must follow. So when we take a look at what the benefits for this would be, is it's definitely the way to encourage mixed use. We heard from a number of folks as they were trying to move development through in that area, saying really they need the residential component. But when we were doing the Chinatown master plan, in order to really activate that corridor, you really do need residential to activate that corridor. And so we didn't want to just limit it to just the Chinatown. Give everybody the same opportunity through that entire corridor, just like we do elsewhere in the city. It's really to promote economic development so that as you come through again, these developments can move through with the residential and do a really nice mixed use project. We do not, if you look at the map that's in your package, the last page, you'll notice that there is absolutely to the west of that, there's absolutely no mixed use. It's all single family residences. So this would allow more housing options through apartments for professionals, elderly housing, young people who want that option, or maybe even some of the folks who are currently in single family homes who want to downsize. So it allows more options on the west side of the city.
You're going right up to 143rd Street.
I'm sorry, sir?
That's going right up to 143rd Street?
Yes, sir, it's going all the way in the entire corridor.
So that's gonna be the whole corridor?
Yes,
And
sir.
the Chinatown motif will only be up to 135th Street?
Correct.
Right.
And then
Correct.
but it continues further north.
Yes, the PCD will continue, that continues all the way through that entire corridor.
200 feet, right, I think?
Right, so we have, the next steps, this will go before City Council on the 26th for first reading, and then it stops, because it has to be transmitted, the comprehensive plan amendment has to be transmitted to the Department of Economic Opportunity, which is the state land planning agency. It takes about 30 to 45 days, which is why that big long title talks about transmitting to all the different agencies. So everybody from FDOT to the different surrounding communities have a chance to make comment on what we're doing. And then it will come back, and we have 180 days to amend it or adopt it, and then that's when the second reading would be scheduled. So at this point, we don't have that second reading scheduled. It's to be determined based upon when it comes back from the State Land Planning Agency. When it does come back, and we do adopt it at second reading, It doesn't become effective until 31 days after the second reading, because that it allows for an appeal at the state level of the amendment. So with that, that's the end of staff's presentation.
All right, at this time, we'll open the public hearing. Anyone wishing to speak to this item is invited to step forward. Please state your name for the record and your address. Calling once for the public hearing. Calling twice for the public hearing. 3 times for the public hearing. No one wishing to speak to this, the public hearing is closed. All right, gentlemen, we can discuss it or we can move straight to motion.
I'd like to
Motion.
move straight to motion.
All right.
Second.
That, yes.
You're going to move to approve?
Move to approve.
All right, Kenneth Each,
Second.
seconds, all in favor?
Aye.
Okay.
Okay. Then we'll go ahead and move to the companion LDR if you have no questions.
We have none at this time, so this will be PC 3-19. This is an ordinance of the mayor and city council of the city of North Miami, Florida, providing for text amendments to chapter 29 of the city of North Miami Code of Ordinances by amending Article 3, Division 4, entitled Conditional Uses, specifically at Section 3-401, entitled Purpose and Applicability, and at Article 3, Division 13, entitled Development Agreements, specifically at Section 3-1301, entitled Purpose and Applicability, further amending Article 4, Division 3, entitled Special Purpose and Overlay Districts, specifically at Section 4-306, entitled Planned Corridor Overlay District, PCD, to establish residential density into State Road 7 Northwest 7th Avenue, PCD, and require a conditional use permit for development within the PCD, providing for repeal, conflict, severability, correction of Scrivener's errors, codifications, and for an effective date. Staff report, please.
Thank you, sir. Once again, for the record, Debbie Love, City Planner, Community Planning and Development. What we're going to talk about now is the actual companion LDR. As you all know, that once you pass the comprehensive plan, then we need to do the companion LDR. If we can pull the PowerPoint up on the screen, please. Once again, this is now the text amendment to the land development regulations that will implement the comprehensive plan text amendment that you all just approved. This is amending section 4-306 to allow it to fix the conditional use permit issue, to clarify that it is up to the density, including the floating units. So you can see that clarification of up to, including the floating units. So it's not up to 125 and then floating units on top of that.
125 with the floaters.
With the floating,
I'm looking at
maximum you can get,
section,
yes.
I'm looking at section 3-13-1. All that is just changing the terminology first, correct? From Plan Development Overlay District to Plan Community Urban Design.
No, that's actually just clarifying that this is applicable. Let me get where you are.
Development
No, what
agreement.
that is that's now, you're changing the fact that there's a couple of different sections of the code here. 1301 actually is where it required development agreements if you were in the planned corridor development.
Yeah.
So remember we talked about how the comprehensive plan requires it through the conditional use permit, and we had to fix that in the text. Now we're actually fixing that in the LDRs as well. So we're just simply striking the planned corridor development overlay district under that requires the development agreement. So it's all these little touches that somehow if you don't catch them, you'll have internal conflicts.
Okay, then again, I didn't mean to interrupt you because
Yes, sir.
that was before what you're looking at, and I wanted to try to follow in line here.
Of course, sir.
Your
Yeah.
changes.
No worries.
Debbie, through you, Mr. Chairman?
Yes.
A question. Just to understand the process, why did you include the floating units in the total rather than separate?
Because that was the intent, is that it is 125 max dwelling unit as far as the density. It was a clarification so that if you have, as your underlying is 6, you can go up to a maximum of 125. So
Right.
you'd request then the difference between 125 and your 6 to get your per acre.
Right.
So that was the original intent, when the comp plan was done, that it's capped at that 125. We just wanted to make sure that it's clear,
So that you don't have bonus using on top of the 125.
correct, right? And, you know, nobody's actually asked for that, but we believe in trying to make things as absolutely crystal, and we thought this is a great opportunity, since we have to touch this area anyway, to go ahead and make that slight clarification.
Aren't
this
we,
pretty much-
we're on the low side, are we not?
Of what, sir?
Compared to other cities, as far as density per acre? Our max is 125, I mean, like North Miami Beach is a heck of a lot more than ours.
It depends upon where they're located. A lot of communities who do not have transit, you know, in that area, they're lower density. So it really just depends upon what the community is like. So it really varies from community to community, and is geared toward their capacity, what has been approved at the state level on their future land use map. So it really goes back to all of the capacity that was approved by the state.
What are we at, just for our, at the new development on Biscayne? What are we at there at,
I'm sorry, what, sir? What development?
on Biscayne, Solomia?
I don't know what it is, to be honest with you. Off the top of my head, I just know that the number of dwelling units is about, that they've been allocated through their conditional use permit, is not based upon, acreage. It's actually based upon just how many that we granted to them. They have 180-something acres out there, and, I think they have like 42 and change dwelling units assigned currently.
They have what?
About 4,200, a little over 4,200
Okay.
currently assigned dwelling units. But in the RAC, in the Regional Activity Center in which they sit, there's a total was allocated of 7,000, but the
Right.
RAC, remember, goes across to that new SDTOD. And
Right.
we have assigned 2,000 of those 7,000 to the new SDTOD. So that leaves about 600 dwelling units.
Okay,
that
I
they
just
can
wanted
use.
to.
Well, what I'm a little confused with here is, we're saying 125 DU per acre as floating units, but it says subject to availability of floating units.
Correct.
So,
If you run out of floating
If we
units, Sim Lloyd.
First come, first served, right?
yeah,
Yep.
so I mean, that 125 then is not guaranteed, is what you're saying
It's
to
not
the
guaranteed
developer?
anyway, in two reasons. It's not guaranteed because the ultimate arbiter of whether or not, the dwelling units are given isn't staff, it isn't the developer, it's the city council. So while they can get up to 125 dwelling units per acre, depending upon city council, they can opt to reduce that, not give them. But it's also then, the other arbiter is, we have 5,000 thereabouts dwelling units, and once they are gone, they're gone unless the city does a citywide capacity analysis and do whatever upgrades result from that infrastructure before the state would actually allow us to have additional density.
So if someone comes to us and petitions for additional units, how are we to how are we to judge whether or not, unless staff directs us that it's okay? In other words, we have to rely on you to tell us that it's okay, that, yeah, it's fine, he's asking for 50, we're going to allow him to ask for 50 or X amount.
Right,
Is that
that's,
how we
and-
have to approach, how we would determine any of the DUs?
right, we look at it based upon the criteria in the code. So staff would say, yes, it meets it, no, it doesn't meet it, and that would be done before it even gets to your level. The only time you'll ever see something come before you is if staff can recommend approval and say it's meeting all of those criteria, because there's a lot that goes back and forth before you even see it. So we may say, no, that's not enough open space, or that's not enough public assembly, and so you need to go back to the drawing board, come back and bring us something back. So we really put them through the ringer on our end before it even comes to you all, but ultimately, no matter what we do, at the end of the day, city council can agree with staff's recommendation or not. You can agree with staff recommendation or not. We say, and look, it meets all of these criteria, you still have the option to say, well, we don't agree. Any other questions? Okay.
None at this point.
Okay, sir, thank you. So
Thank
once
you.
again, it's the same issue with correcting the conditional use permit. It's also, again, acknowledging the Chinatown design guidelines.
Right.
So you'll see that the comp plan, a lot of the language in the LDRs mirror your comprehensive plan. And again, the same benefits, encouraging mixed use, economic development, expanding the housing options. And critically, it really is that now you've got, in addition to the internal consistency with what was required by the comp plan for the corridors, you now have the consistency with the comprehensive plan amendment you just approved. So
Okay.
the next step on this is slightly different, because this is the LDR. So it will go for first reading along with the companion comprehensive plan amendment, just like it did with you tonight on the 26th. However, as you remember, I told you it has to be transmitted to the department.
Right.
So we have to set now this LDR aside until after it comes back, the comprehensive plan amendment comes back from the state. It gets approved at second reading along with the second reading of the LDR amendment. So they kind of like, this reading will stop after first reading at city council and kind of wait for the results of DAO. Because whatever amendments they may require that the council approves in the comp plan amendment, that may adjust the LDR.
So it could be well into the fall, hypothetically.
I would tell you it would be at least May or June, because it all depends upon how quickly we can reschedule this and how it can get through DAO. So once again, it has to get on to city council agenda. We have to figure out what their comments are. That's gonna take at least 45 days to get the comments back, get a new staff report prepared. So you're probably looking at 4 months, maybe?
Yeah.
I usually tell everybody, give it 6 months, and then that's a good conservative number.
Well, that's, and given that everybody takes off the month of August, you're looking in the fall.
Yeah, if we can't get it into the June or July, then yeah,
which is-
definitely.
Other things may crowd it out if it can happen. Okay.
Hopefully not, but, because we're gonna try to stay on track and move this as soon as we can, because this is a critical piece of development here in the city. So with that, that's the end of my presentation, sir.
All right, we'll open the public hearing at this time. The public hearing is now open. Anyone wishing to speak to this item is invited to step forward. State your name and address for the record. First call, second call, anyone wishing to speak to this? Final call, anyone wishing to speak to this item? Hearing none, public hearing is closed. Chair will call for a motion.
Make a
I'll
motion.
make a motion.
Fight over. Kenny, you'll get the motion
Yeah, I make the motion. We approve it.
to approve. Mike, you second? All in favor?
Aye.
All right.
By the way, this is very good.
I'm sorry, sir?
I said, this is very good what we did tonight. I think it really changes a lot of stuff and makes things better for 7th Avenue.
We would all certainly hope so. It's been a neglected area for a very long time.
Yeah.
All right.
Staff is excited about it.
I got, before I bring up two things.
All right, go ahead, Kenny, then we'll wrap it up.
Two articles in the Wall Street Journal, one dated January 26, 27. And the state of Oregon is going to pass a whole rent control for the whole state. And what they're blaming it on is because housing is getting so expensive in Oregon. What's causing it is development restrictions. They're making it so ridiculous, like in the city of Eugene, that you can't build, especially in the infrastructure, the current infrastructure, the current buildings. You want to rip them down and go high and so forth, and so you can't do it. And as a result, when you don't have the housing for the people out there, the rents skyrocket, and that's what's happening in California. So, you know, maybe some of our elected officials would see that, and we talk about density and traffic and this and that. Well, density is good, it's, you know. And then today, there was an article in the Wall Street Journal about people leaving Illinois, Connecticut, New Jersey, New York, and coming right down here to good old Miami. And the reason being is the new tax structure that you can only knock off $10,000 on your federal income tax of your state income tax or your property tax. And people in these high-priced states like California, where you're paying 13% state tax, in New York you're paying a city income tax and a state income tax, plus your real estate tax, they're leaving because they can't write it off anymore, only up to 10 grand. And what was happening here, our housing market, and especially in our condos, our luxury condos downtown, was slowing down a little bit with the foreign market. Now it's picking up again. So, you know, I hope we don't miss, and we always seem in this city to miss the boat. And I hope we can start changing the direction in which we're going. Density is good, height is good, redo the infield. You know, I mean, that's what I feel like I'm
Well, I think,
talking to the mirror.
well, I think that's some of what we did here tonight.
Well, we gotta go a lot further, Mike, believe me.
Yeah.
Oh, we'd hope so.
One step at a time, but always compliments to staff that you're trying and looking out for stuff. You know, out of the box thinking, sort of trying to come to a better way of looking at things and doing things that makes it easier for the city to grow and for people to have opportunities, like you mentioned. People who want to move out of their houses who perhaps would rather live in an apartment or a condo, you know, and these kind of options, as you mentioned earlier, is a wonderful way of looking at some of the new developments, is providing people options, you know, to stay within the city. And that's so important, that we create opportunities for people to stay here in our city. People who grow here and go to school here shouldn't have to move away to have a different kind of opportunity, you know, than what we offer.
Thank you, sir, appreciate that.
All right. Well, having said that, and yes, Ms. Love, I'm very impressed with the way this is being handled. We're lining this up properly and not taking one half and then trying to fix the back half 6 months or a year later. These things need to be done together, and we're moving along on this very well. All right, we have no committee reports, no old business, no new business. Our next meeting will be on Tuesday, the 5th of March at 7 p.m. And with that, the chair... Oh, by the way, a question. Does the chair actually have to call for a motion to adjourn, or can the chair simply declare the meeting adjourned?
It's always nice to go for a
Well, it may be nice, but is it required?
I didn't see that one in the presentation.
Yes, that was not in the presentation.
With all due respect, I'm not sure.
You're not sure.
I suppose
think
there could
we-
be objection if you declare
Right.
adjournment.
Either way, I make a motion to adjourn.
So moved.
Seconded by Mr. Reach. All in favor?
Aye.
That's it. Thank you very much, everybody. It's great fun. I think we got something good accomplished tonight, and we're out of here in an hour.